Good morning, everyone. Welcome to the Legal Aid New South Wales and Revenue New South Wales Law webinar called What's New with WDOs. My name's Meredith Osborne and I work in the Work and Development Order Service at Legal Aid. I'm here with Jess Coleman from Revenue New South Wales, the resolution team, and also Kerry Wright from Legal Aid and Tanya Oslin from Revenue. So it's a real team effort this morning. Thank you all for being here. We're broadcasting this webinar from Parramatta, and I want to acknowledge and pay my respects to the traditional owners and custodians on whose land we are broadcasting from today. So how's this going to work? The webinar will go for 30 minutes in total, which will include some time for questions and answers at the end. If you have a look at the questions and control panel, you can type in questions for us during the webinar, and Tanya will respond to you individually. And we're hoping to have some time at the end where we can also respond to all of you with some questions that are coming through. So in the control panel is a box where you can type in your questions. Sometimes your control panel might shrink, so to expand it again, there's a red button with an arrow in it. If you can't see the full control panel now, or if the control panel shrinks, you can click on that red button to make it reappear. We're also going to be doing some polls throughout the webinar, so we might do a quick one now so you can test it and just to make sure that you can hear what we're saying. So opening up poll question 1 now. What is your experience with the WDO scheme? Okay, so responses are coming through. Kerry's we'll close that now. So we'll just give you the results of this. So about 18% of you have said that you're new to WDOs and you know nothing about them. So fantastic to have you with us. Welcome. We've got 23% of you telling us that your service is a WDO sponsor, but you haven't supported anyone yet, so this is also going to be a really useful session for you. Around half of you, 49%, have done. You've got some experience with WDOs, between 1 and 15, and 10% of you have heaps of experience, so we're going to be contacting that 10% and getting you to deliver the next webinar. So just after the webinar, you're going to receive a survey, and it would really help us if you could complete it. Then about an hour after the webinar, you're going to get an email with some links to where you can get some more information and help. So I think now we're ready to get stuck into the content of today's session. So just before we start, I'm just trying to click through. Yeah. Okay, there we go. So today we're going to cover these topics. We're going to do a quick overview of fines and WDOs, particularly for those who are new to the scheme. We're also going to flag some really important changes to the WDO guidelines that occurred in May 2017. We're going to also do a quick update on some fines management changes, and then we'll look at some of the resources, contacts that we'll send to you at the end of the session, plus also time for questions. Also just wanted to flag the new design, the new look of our materials, and you can see that from the slide design. Legal Aid has produced some new postcards to promote WDOs to your clients. So it's got this sort of look and feel, and on the back of the postcard your clients can assess whether or not they might be eligible for a WDO, or you can do that with them. So if you'd like to order batches of those postcards, just hop onto the Legal Aid New South Wales website on the publications page and you can order those resources, as well as posters and other brochures. So you probably know this, but there are 2 types of fines in New South Wales. There are court fines, which are paid directly to the court, but if they're unpaid, they can be enforced through Revenue New South Wales. And then the second type of fine is called a penalty notice. There are many, many thousands of different penalty notice offences in New South Wales, issued by police, transit officers, council rangers, and they are also often collected and always enforced by Revenue New South Wales. Important to know that you can do a WDO for both a court fine and a penalty notice fine. So what happens for your clients or customers if they don't pay? So if a fine is unpaid, it will end up with Revenue New South Wales, and they will enforce that. They've got a range of enforcement powers, which you can see. We'll work through them in a minute. But also there's a fee of $65 that is added to the fine, so the amount goes up. So generally, RMS is contacted, Roads and Maritime Services, to suspend your driver's licence or vehicle registration. That's the first level of enforcement. And there's another $40 fee added to that as well. Now, Revenue New South Wales can also commence what's called civil action at any time, which also have the additional costs. So let's have a look at what the civil action is. So the first thing is that they can take money straight from a person's bank account. That's called a garnishee order. Or wages. Property seizure order, so that's where the sheriff can take property, things that people own, and sell them to recover some of the debt. And there's also additional fees attached to that. Something called an examination summons, which I don't think it happens very often, but it's an order that a person must attend on a specific date to answer questions about their financial circumstances, and the purpose is to get information about income, expenses, assets and debts. There's a charge on land, which it's like land can't be sold. The debt will be attached to the property. And finally, the Fines Act does include a power that the Commissioner for Fines Administration can issue a community service order as well. But it's important to know that all enforcement action stops when fines are brought under management. So the message, it's a very important message that, don't ignore a fine, take action, and there's a range of options for dealing with it, such as a payment plan or a WDO. So let's move now to look at the Work and Development Order Scheme. So you probably all know this, but it's a world first program that has allowed people to clear fines through a range of activities or treatment programs. It's achieved amazing results since it was first piloted in 2009 and then became permanent in 2011. So we're hoping that by the end of this year, around 100 million in fines debt would have been cleared through the WDO scheme. It's sitting at about 93 million now. And we've got over 2,300 sponsors, just like your services, participating in this scheme. And just wanted to take this opportunity to thank you all for your commitment to this program, because it really is making a big difference for many vulnerable people in our state. So the WDO scheme is delivered by 3 organisations. Firstly, there's Revenue New South Wales, who manage the fine system and the collection of unpaid fines. They also issue WDOs, and you probably know about the WDO hotline, 1300 478 879, and the staff on the hotline can help you with any questions you have around reporting or using the portal.
Even guidelines questions as well.
Or guidelines questions. And also Revenue New South Wales will refer clients across to us at Legal Aid, clients who need particular assistance with getting their fines under control. A new development is that Revenue New South Wales now processes all new sponsor applications and variation applications. So that's all done through Revenue now, not through the Department of Justice. Moving on, the other partner in the scheme is the Department of Justice. They work with our services to administer the WDO scheme in New South Wales. They oversee the WDO guidelines and changes to the guidelines, and they also are responsible for a WDO audit process. Legal Aid is the third player in the scheme, and we have 6 small regional teams across New South Wales. Our job is to promote expansion of the scheme and to promote access to WDOs. We provide sponsor training, we develop resources, and we also provide a specialist service for clients with unpaid fines. If you want to know about your latest WDO, where your closest team is, you can hop onto the Legal Aid website and just search WDO. So again, why is the scheme life-changing for our clients? Well, as we mentioned, enforcement action stops pretty much immediately, definitely within 24 hours. That's right, Jess, isn't it?
Yeah, once the work and development order is opened, enforcement action ceases.
And so what that means is that your clients will get license or other registration suspensions lifted straight away, so they can go about everyday life activities, taking the kids to school, going shopping, getting to their job. We also know that the WDO scheme alleviates debt stress and anxiety. We know this from the 2 evaluations that have been conducted of the scheme. In fact, in the last evaluation, 97% of sponsors surveyed said that this is the primary benefit of WDO, just taking that the mental health benefits of alleviating debt stress. But the scheme also is helping clients address the reasons why it might have been difficult for them to manage their fines in the first place. And we know that the activities and programs that clients are participating in is helping them develop new skills and also improving their motivation and engagement with treatment and services. So we're just going to have a look now at who is eligible for a WDO, because there has been some important changes here that we want to flag with you. So when you log into the self-service portal, you'll now see that there are 6 different categories of eligibility for a WDO. And the one I particularly want to flag with you is that all under 18-year-olds, or if you're 18 and under, you're able to automatically access a WDO. And this is because we were finding that young people were sometimes having trouble getting a WDO because they weren't on Centrelink benefits. They weren't able to provide the evidence of household income. So now, if you have anyone under 18, they can do a WDO. However, as a sponsor, you still need to be satisfied that that young person is unable to pay the fine and that they don't possess substantial assets. Just flicking through the other eligibility criteria, so as you know, acute economic hardship and anyone on a Centrelink benefit is deemed eligible for that. If your client is homeless, if they are experiencing mental health issues, if they have intellectual disability or cognitive impairment, or a serious addiction to drugs, alcohol, or other volatile substances. So I think we were going to do a quick, I just wanted to mention too that Oz Study and AB Study are now included in the list of Centrelink benefits for acute economic hardship. Another very important change is that people who are experiencing family violence involving some form of financial abuse are now recognised in the guidelines. It's a recognition that they're often unable to access family income, and for that reason they shouldn't be precluded from the WDO scheme. So I just wanted to flag that with you. Another important change is that under mental illness, that ground of eligibility, gambling disorders are now recognised as a mental illness, and that's in accordance with the 5th edition of the DSM, the Diagnostic and Statistical Manual. So that's important. If you have a client with a gambling addiction, they are eligible for a WDO under mental illness. So we might just do a quick poll now before Jess talks about some portal issues. So the poll question is, a person is eligible for a WDO on the basis of serious addiction can participate in any WDO activity. Is that true or false? We've got the results coming through now.
Okay, so we've just closed the poll.
Yep. So that is a really interesting response. So 81% felt that someone who has a serious addiction can do any activity. The answer is actually false. If a person is only eligible for a WDO on the basis of their addiction, the only activity they can do is drug or alcohol treatment. So that's a very important thing to remember. All other eligibility allows a person to do any other activity, but if they're only eligible because of addiction, they must do drug and alcohol treatment.
So just keep in mind, if you are dealing with a client who meets more than one eligibility and one is drug and alcohol and you'd like them to do multiple activities, please remember to tick multiple grounds to allow you to do multiple activities.
That's a good point, Jess. Thank you. So you want to talk about the portal?
So with the recent changes to the guidelines, and an update to the portal in August, there has been some changes. So the very first one is on the first screen. So the first question asks about penalty notices or court fines. In 9 times out of 10, the answer to this question will be no. The only time you should answer yes is if the client has indicated to you that they have a penalty notice and you have that reference number. By putting yes, it is actually going to go in queue for us to manually look at it. So if they don't know or they don't have any penalties, please hit no, which will allow our system to match it up and open it manually. Automatically. The next question asks about document reference number. Please, if you've got one, pop it in. Our system does require a 3-point match to allow it to match up directly and open. So if you've got 3 points, please put it in to assist with matching the application. Okay, so another thing that changed with the acute economic hardship to allow juveniles to be eligible, it is listed as a separate ground, but just to reduce confusion, if you've got somebody under the age of 18 and that's their ground, you can simply tick it. It does count as acute economic hardship, but it just allows us to identify the young people that are going through onto that criteria. Okay, so, and as Meredith mentioned earlier, the addition of AD study and Oz study has been added to the portal. This will assist all clients receiving a Centrelink benefit to participate in a WDO. Okay, so we're now going to do another poll. The question is a person with a gambling disorder eligible for a work and development order? So the answers are yes, no, or unsure.
Great. And it just to remember that it comes under mental illness. It doesn't come under addiction.
That's right. So as you can see, everyone's got that question right, which is fantastic. Yes, it's a very good point to remember that despite it being a gambling addiction, it comes under mental health, not an addiction.
Okay. So back to me?
Back to Meredith.
Okay, so let's just have a quick recap of the activities that can be undertaken for a WDO. So as you can see from this slide, there are 6 types of activities that you can do with your sponsor. Each activity has a different monetary value, as you can see on the screen. So sponsors are approved to undertake some or all of these activities, and we really encourage sponsors to sort of review your approval from time to time, because if you've taken on a new program, you might be eligible to be offering, you might be able to offer additional activities, but you can't offer that activity unless your approval includes that. So if you do want to add any activities to your sponsor approval, please just submit a variation form to Revenue New South Wales. There's an online process that you can access through the Revenue New South Wales website. So, in terms of just flagging the main changes to the WDO guidelines for activities, the first one is around case management. Case management, there's always been a bit of confusion around this because it was included under the activity called financial or other counselling. So case management was regarded as, attendance at case management meetings was regarded as, it was counted as counselling. But that was confusing for some service providers, so we've now got a definition of case management in the guidelines, and it's very clear now that you can include case management as an activity for a WDO. The other change is that any mental health treatment, whether it's voluntary or involuntary, or whether it's court-ordered or not, can be included in a WDO. Now, this is just for mental health treatment, really important. So any treatment under the Mental Health Act, tick, it's in. But also, this is a new development, that any treatment or activities undertaken in accordance with what's called a Section 32 order, it's an order made under the Mental Health Forensic Provisions Act, can be counted towards a WDO. So what is a Section 32? Well, it's commonly used by magistrates to divert people with mental health conditions out of the criminal justice system. to treatment or support that they need. So it's a way of bypassing the court system, and a person gets a court-mandated treatment plan instead. There's no criminal conviction recorded, and the person is not found guilty. So we used to have these types of orders used to be excluded from the WDO program, but now they're in. And let me just give you a quick example, a case example of how it might be applied. So Tom is a legal aid client. He has schizophrenia and developmental delay, and he lives in a group home. He doesn't always take his medication, and he's been under the treatment of the community health team. He's been doing a WDO through community health and has been clearing his fines. But then he had a matter in the local court, and the court dealt with his issues under Section 32 of the Mental Health Forensic Provisions Act. And what this meant in the under the previous guidelines is that Tom's treatment plan was no longer voluntary because it was court ordered, so we couldn't count it. So the new change to the guidelines will allow for Tom to be able to count his mental health treatment under the Section 32 order in his WDO. So that's a really positive development. So Tom can continue with his WDO and with his mental health treatment as normal. The third change is there's more clarity now in the guidelines around what a voluntary program is as opposed to a court-ordered program. So programs like credit and merit can be counted because they're voluntary, but court-ordered activities other than mental health, such as activities taken as part of the drug court or under sentencing programs, can't be counted towards WDO. Very happy to talk to you all about this offline. If you want more information, please contact us and we'll explain how that works. Again, that's an area, court-ordered activities or voluntary activities, it's an area that we're continually reviewing. But at the moment, it's very clear that a court-ordered activity can't be counted towards the WDO. So Jess, over to you to talk about administration updates.
Yeah. Okay, so the first one is evidentiary requirements. For mental health, intellectual disability and cognitive impairment or serious addiction to drugs, alcohol or other volatile substance, the sponsor must be satisfied and may be asked to verify that the work and development order is more appropriate for their clients than paying their fines. So we all know that all our clients that are doing work and development orders are vulnerable, so it's just making sure that the work and development order is the most appropriate avenue for them to pay their fines. Third-party referrals, the guidelines provided the sponsors with more information on the types of third-party referrals that are appropriate for a WDO client. However, it is important to strike a balance between ensuring the referrals are only made to appropriate third parties and making sure that there isn't the administration burden on the services that are not able to provide the activities direct. It also sets out information in relation to fees, gifts and personal benefit. It actually states what it means for sponsors, that fees and gifts that
they undermine the sort of intent of the scheme, I suppose.
Yeah, so we are trying to ensure the integrity of the scheme is at a high standard. So personal gains to the people providing the scheme isn't what the scheme's all about. It is about helping our vulnerable people to pay their fines. And conflict of interest. We all know, particularly with sponsors that are out in regional areas, that conflicts of interest cannot always be avoided. We understand this, and the guidelines now outlines this. As long as the conflict of interest is declared and there's ways of managing it, and it is actually now declared on our portal so we can review it, 9 times out of 10 there is no issue, and we just monitor the activity. Records, so records must be kept for 5 years. That hasn't changed, but it's just made it more specific in the guidelines. Audits, we are aware that audits can happen. The Department of Justice do random audits where they sample WDO activities and the work and development orders in general. These audits are not a daunting process. It is really just about ensuring the integrity of the scheme and an educational process. If there is an issue, we are happy just to work with you to improve it. And it really is just a training exercise, isn't it, Meredith?
Yep.
Right. So the next poll question. So about record keeping, how long do records for WDOs need to be kept by another sponsor after, by a sponsor after the WDO is finalised? Okay.
So the correct answer is under the new guidelines, you have to keep records for 5 years.
Yes, which 90% of you have answered correctly, so that's fantastic.
Great, so we are now getting towards the end of the webinar. Just a reminder, Tanya is typing away here. Please keep sending your questions through to Tanya, and she is responding to you all individually. We'll also be collecting all of these questions, and they'll go to a consolidated FAQs document, which we'll send out to all of you as well. So a few other quick updates. As we mentioned earlier, all applications and variations, sponsor applications and variations, are now being managed by Revenue New South Wales. So they review the applications, make sure that everything's in order, and they will then send that across the Department of Justice to approve. Again, you can get all the application and variation forms on the Revenue New South Wales website. A major change, a recent change, was in March this year. The Fines Act and the Victims' Rights and Support Act were amended. So Revenue New South Wales is now the agency that is collecting what's called a victim's restitution debt. So, what is that? Well, we call them VROs, Victims Restitution Orders. It's an order made by the Commissioner of Victims' Rights, generally against a person who has been convicted of an offence relating to an act of violence, and where the victim has received some sort of victim support payment. So a victim's restitution aims to recover some of that money from the perpetrator, from the offender. Some of those debts are old and they're large, they're big debts. So there are a range of options. There'll be options available for dealing with them, including WDOs, and all sponsors should have received a communication about this, and I think we will include that again in the package so we can just give you some more information about it. WDOs will be available as a repayment option. But it's quite a complex area, and what we would be suggesting is that if your clients do have a victim's restitution order, it's quite important for them to get some legal advice about that, around what their options might be and how they can address that. So that's all I'll say about that for now, but please encourage you to get in touch with us and we can give you more information. And just a final reminder that Legal Aid New South Wales, we've got 22 offices across the state. We provide a specialist fines service, but also all of our offices have civil lawyers there who can give advice on fines and help with write-offs and other fines management options. And you can find out, hop onto our website and you can see where we're located and how to contact us. And I think we are now, here's a list of the resources that you'll be sent at the end of the webinar. We'll also be sending you the FAQs document, and as I just mentioned, something more on victims restitution orders. And finally, how do you get in touch with us? Well, there's the WDO hotline number for Revenue New South Wales. They can help you with any portal questions or other general WDO questions, guidelines, whatever. Our service, probably the best way to contact us at the moment is just through our general WDO at Legal Aid email. We can provide sponsor training and support, and we also provide our specialist fines service to clients with fines debt. Right. So I think, do we have 2 minutes maybe to answer a question. Can we see where we'll just pull these up. Oh, so many fantastic questions. Where do we start?
Nice work for Tanya answering the questions as we go.
Jess, do you want to pick one that everyone might be interested in.
Okay, so there's a question of how do you prove domestic violence. So this is a really good one. As Meredith mentioned, there was changes in the guidelines that allows this to be taken into consideration. So what would the evidence for domestic violence be? So if they're working with a service in relation to domestic violence that can outline this person's situation, how it's impacting on the client, how it makes the work and development order eligibility proving difficult, and that would be, they would just need to keep that on their records, and the WDO would be going under acute economic hardship.
Yeah, or if there was an AVO in place, for example. So the reason why this has been such an important change is Revenue New South Wales won't be required, if a person is a victim of DV, they won't have to supply a whole lot of evidence around their financial circumstances
because they
if they're not on
Centrelink
or if they don't have access to it. So, okay, so there's a question here. Oh, I've just lost it. Our organisation is wondering, is that the one?
Yeah.
Our organisation is wondering what level of records we need to keep. Are case notes on SIMS enough proof that a client is engaging in case management?
So we really just need to be able to show evidence of the hours that was attended. So if your case notes say it was an hour appointment, we don't really need to know what was discussed in that, just that the client attended and engaged.
Yep.
So some sponsors even just get timesheets signed. As long as you can provide the evidence, it's not really what it is.
And just an important reminder is you don't have to send in proof or evidence of completing activities into Revenue New South Wales. You just have to keep those records yourself, because if you were ever audited, it was just you've got the evidence on file that the client was eligible for a WDO and that they've completed an activity.
Right. The only thing you need to provide to Revenue New South Wales is you need to enter the client activity reports on a monthly basis on the portal. Now those reporting periods are from the 15th of one month to the 14th of the next, and they open on the 15th of each month.
I want to clarify that one about the first question. This person.
Yeah, no, I'm just answering.
Yeah.
Angie. AG or whatever. Is that who it is?
Okay, so here's a question. With the first question in the online WDO application, can you tell me again when we tick yes? I always tend to tick yes.
The only time you would tick yes is if you're aware that the client has a fine that is less than 3 months old, that's still a penalty notice. The reason you tick yes is so we're aware at Revenue New South Wales, so we go looking for that debt. By ticking yes, it does sit in queue waiting for us to look at it. So unless a client has given you a penalty notice or advised you that they've got a fine very recently, I would recommend ticking no for that question, which will allow it to go for automatic opening.
There's another really good question. Someone has asked us about whether Centrelink debts or Centrelink fines can come under a WDO. Really good question. We get asked this a lot at Legal Aid. You know, what type of debts can be covered? You know, can we cover Housing New South Wales debts or, you know, Centrelink debts? The answer is that at this stage it's only fines debt.
Yes.
So it's only if the person has a court fine or a penalty notice fine. So it's under the Fines Act. So those other types of debts can't be subject to a WDO yet. But I can mention that there are some really interesting projects underway where one in the community housing sector where a housing provider is using a WDO type model to support clients with rent arrears, for example. So it's certainly a model that's been picked up and replicated in other areas.
Definitely.
So we've still got lots of you online. We have gone just 4 minutes over, but we might just do another one or two questions because you're all still engaged and with us. So we'll keep going for a bit longer.
Do you need to complete a paper form from the client and get their signature? Yeah, you don't need to get their signature. It was part of the old guidelines that was required. As long as you've got the client's permission, you've got proof of eligibility and how they meet the grounds, and you've cited the ID, that's all that you need in order to put them on the work and development order. You don't need any signed forms or anything like that.
And someone has just asked us, what's the WDO hotline number? So can
1300 478 879.
So, yeah. Anything else, or shall we?
Payment plan number, or
Yeah, do you want is a payment plan number enough to set up a WDO, or do we need a penalty notice number?
You can use a payment plan reference number when submitting a work and development order application. You can put it under the document reference number. Our system will look for enforcement order numbers, payment plan reference numbers, case ID numbers. So yes, you can certainly pop it in there. A penalty notice number isn't required.
And there was a good question here about case management. Do you want to explain that one, Jess? Set up a WDO for case management. So one of you has asked, when I've set up a WDO for a case managed client, I have not been able to select case management. Why is this?
So the reason for this, there was a change made to the portal in August that was to prevent case management from being a standalone activity, so you needed to enter another one first. There has been further change to the guidelines, and that's not the case, but our system has not yet been able to be updated to include it. So if you've got a client who is only doing case management, in that case you'll be best off ticking other and typing in case management. But if they are doing multiple activities, just pop the other activity in first, and then you would be able to put the case management in. We're hoping to get that rectified shortly.
Great. One last one. Which one did you think, Kerry?
why is educational courses $50 an hour?
Oh, someone has asked us to explain the different rates for different activities, and that educational courses are at $50 per hour. So they're the rates that are in the guidelines. So they've been in place since the scheme was piloted. I think the rate of unpaid work, often people say to us, why is unpaid work different to educational courses? Unpaid work is $30 an hour, education or counselling is $50 an hour. And I think it was, the reason was to bring it more in line with what the pay rates were in that sector. But yeah, that's my understanding of it. But you've also got, so you've got the hourly rate activities, and then you've got the treatment programs, which are called compliance rate activities. So you can get up to $1,000 a month for complying with a mental health treatment plan, or with drug and alcohol treatment, or with a mentoring plan, regardless of the number of hours you do. So, for example, you could have a client who is participating in perhaps, you know, only 3 or 4 hours of mental health treatment a month. So they might be doing a one-on-one sessions with a psychologist or counselling, plus they're also doing some group work. If they're fully complying with their plan, they can get the full $1,000 credit.
Yes, that's right.
Yeah, I think we might.
Yeah, so we might call it time. Thank you, everybody, for attending this morning, and we hope it was beneficial for you. And thank you for participating.
Yeah, and thank you to Kerry, who has been steering the WDO bus. And big thanks also to Tanya, who has been responding to your questions individually. Have a great day, and thanks again for supporting the WDO scheme.
Thank you.